Hello everyone, my name is Disha Mehta, a legal intern at Lexis and Company and a law student at Gujarat University. So today we are going to talk about the major labor laws which are prevailing in India and everyone should know about the same. So basically we are going to talk about the major labor laws acts which are prevailing in India. So let us start. So in India at present, stands at a place where being a country of superpower is not that difficult if taken care of certain aspects. The major obstacle that stands in between the ambitious project meant for the country is labor law in India. So, the topic of labor law and its reforms have always been a topic of major debate or topic of major concern. Thus, it's essential for people working in private as well as public sector, they may be unorganized or organized sectors, to know about the prevailing laws and rights as well as the reforms. So, here are the most important acts of labor law in India which everyone should know. The first among that is the Payment of Wages Act 1936. Now, what does the Payment of Wages Act says? So, it says that it aims at dodging avoidable delay of reimbursement of wages without any sort of deduction from the wages. Under this, the employers have no right to take away any money and they have to pay the reimbursement each month on time. To your surprise, even if you are terminated from the services, you are qualified to take your salary for that particular month. So, this is the act of payment of wages. The next important one is the Industrial Dispute Act 1947. So, this labor law in India is found meaningful by many. For example, if you have a dispute with your boss, you could settle it down through the legal means. The employer can't throw you out just like that. They have to give a notice of at least 6 months before they fire you out. So, this is the Industrial Dispute Act. The next one we are going to talk about is the Workmen's Compensation Act 1923. Now, what does that say? So, it is one of its kinds that is helpful for the person injured in an accident. So, the Workmen's Compensation Act 1923 intends to provide financial protection to the workers as well as their dependents in the form of compensation in the case of accidental injury. So, this is the Workmen's Compensation Act 1923. The next one we are going to talk about is the Payment of Bonus Act 1965. So, as a part of profit or productivity, the Payment of Bonus Act 1965 targets to provide a bonus to their employees. So, this act is more helpful for the employees who receive their salary or wages up to Rs 15,000 per month and who are involved in any sort of work. No matter if they are skilled, unskilled, highly skilled, they are entitled to get bonus if they have worked for at least 30 working days in that particular year. And do not forget to note that within the time period of 1 year, you can claim your right to the payable bonus. So, this is the act of payment of bonus. So, the next one is the Payment of Gratuity Act 1972. So, this act says that gratuity is a part of the salary received by the employees. So, the company has to provide them this in the form of gratitude for the services performed by them during their tenure. So, it is one of the retirement benefits that the organization gives to its employees at the time of leaving the company. But for this, they have to complete 1 year of service to get the benefit of gratuity in case of his or her death. So, this is the act of payment of gratuity. So, these are the 5 main acts, and the remaining 5 which we are going to discuss will be discussing in the next part of the video, which is part 2. And if you have any doubts regarding any of the topics, please feel free to write down in the comment section below. And also please write down if you have any queries in the previous topics or any previous points. We will be happy to help you. Thank you.